The Constitution, a document that has stood the test of time. It's the bedrock of our nation, the foundation upon which our nation is built. It's the document that protects our individual liberties from the tyranny of the majority, ensuring that our rights are safeguarded. But the Constitution, like any document written centuries ago, can be open to interpretation. Its age and historical context can sometimes make its meaning seem distant or unclear. That's where originalism comes in. It provides a method to interpret the Constitution in a way that remains true to its original intent. Originalism is simple. It means interpreting the Constitution based on what the words meant when they were written, understanding the context and the intentions of the framers. It's about understanding the original public meaning of the text, the way it was understood by the people at the time it was adopted. Why is this so important? Why should we care about the original meaning? Because it's the only way to ensure that the Constitution remains a fixed standard, not a malleable tool for those in power to impose their own views. It prevents the judiciary from becoming a legislative body. Think about it. If those in power can simply reinterpret the Constitution to mean whatever they want it to mean, what's stopping them from rewriting the law based on personal beliefs? What's stopping them from imposing their own moral judgments on the entire country? This could lead to a loss of the very freedoms the Constitution is meant to protect. Originalism is the only way to ensure that the Constitution remains the supreme law of the land, a constant and unchanging guide. It's the only way to protect our individual liberties from the whims of those in power, ensuring that our rights are not subject to the changing tides of political opinion. It's the anchor of our liberty, the steadfast protector of our freedoms. Some argue that originalism is outdated. They claim it can't possibly be applied to the challenges of the 21st century. They say it's a rigid, inflexible approach that can't adapt to modern technology and societal changes. This is simply false. The Constitution doesn't list specific technologies, it outlines principles. Take the Eighth Amendment, for instance, which prohibits cruel and unusual punishment. The founders obviously didn't have lethal injection in mind, but they did establish a principle. Punishment shouldn't be barbaric or disproportionate to the crime. Originalism applies that principle to modern methods of execution. The same goes for the First Amendment's protection of free speech, the internet, social media. The founders couldn't have imagined them, but the principle of free speech remains the same. Originalism ensures that the First Amendment protects our right to express ourselves, regardless of the platform. The Constitution was written to stand the test of time. Originalism is how we ensure it does. It's not about ignoring new challenges. It's about applying the founders' wisdom to the issues of our day. The opposite of originalism is often called living constitutionalism. This concept suggests that the Constitution is not a static document, but a living, breathing entity that must adapt to the changing times and societal norms. This philosophy argues that the Constitution must evolve with the times, reflecting the current values and needs of society. Proponents of this view believe that a rigid interpretation of the Constitution would render it obsolete in the face of modern challenges. Its proponents claim that we can't be bound by the views of dead white men from centuries past. They argue that the framers could not have anticipated the complexities of today's world, and thus, the Constitution must be interpreted in a way that is relevant to contemporary issues. This sounds appealing on the surface, but it's a dangerous path. While the idea of a flexible constitution may seem progressive, it opens the door to significant risks and uncertainties. Who gets to decide how the Constitution evolves? This question is at the heart of the debate. If the Constitution is to change, who has the authority to make those changes? Whose morals become the new standard? The subjective nature of morality means that different people will have different interpretations of what is right and just. The answer, unfortunately, is unelected judges. These individuals, who are not accountable to the public, would have the power to shape the Constitution according to their personal beliefs and values. Living constitutionalism gives them the power to impose their personal values on the entire nation, bypassing the democratic process. This concentration of power in the hands of a few undermines the principles of democracy and self-governance. It becomes a game of judicial roulette. The interpretation of the Constitution could vary widely depending on the personal views of the judges who happen to be on the bench at any given time. Rights are no longer secure. They become subject to the whims of whoever happens to be sitting on the bench. This instability can lead to a lack of trust in the judicial system and the erosion of individual rights. This undermines the very purpose of a written constitution, to provide a stable framework for government, protecting individual liberties from the shifting sands of political opinion. A written constitution is meant to be a steadfast guide, not a document that changes with the tides of popular opinion. Living constitutionalism may sound progressive, but it's actually regressive. It harks back to a time when laws were arbitrary and subject to the whims of those in power. It takes us back to a time when the law was whatever the king said it was. This kind of legal uncertainty is what the framers of the Constitution sought to avoid by creating a written document with clear, enduring principles. We need to resist the allure of living constitutionalism and hold fast to the original meaning of our founding document. By adhering to the original intent of the framers, we ensure that the Constitution remains a stable and reliable foundation for our nation's laws and governance. Section 4. When Judges Go Astray, Cautionary Tales from History. Throughout history, the judiciary has played a crucial role in shaping the legal and social landscape of nations. However, there have been moments when judges have strayed from their duty to uphold the Constitution, leading to dire consequences. History is littered with examples of what happens when judges abandon originalism and embrace judicial activism. These instances serve as powerful reminders of the importance of judicial restraint and adherence to the original text and intent of the Constitution. The Dred Scott decision is a chilling reminder. This infamous case is often cited as one of the worst Supreme Court decisions in American history. In 1857, the Supreme Court ruled that Black Americans, whether free or enslaved, were not citizens and had no standing to sue in federal court. This ruling effectively denied an entire class of people their basic human rights. This decision, rooted in the racist prejudices of the time, twisted the Constitution beyond recognition. It ignored the principles of equality and justice that the nation was founded upon. It ignored the clear intent of the founders to create a nation where all men are created equal. The ruling contradicted the very essence of the Declaration of Independence and the vision of the Founding Fathers. The result was a deepening of the national divide over slavery, ultimately culminating in the Civil War. This conflict tore the nation apart and resulted in immense suffering and loss of life. Another egregious example is Korematsu versus United States in 1944. This case highlights the dangers of judicial overreach during times of national crisis. During World War II, the court upheld the internment of Japanese Americans, arguing that national security trumped individual rights. This decision was a grave injustice to thousands of innocent people. This decision, fueled by wartime hysteria and racial prejudice, blatantly violated the Constitution's guarantee of equal protection under the law. It stands as a stark reminder of the perils of allowing fear and prejudice to influence judicial decisions. These cases stand as stark warnings. They remind us of the critical importance of judicial integrity and the need for judges to remain faithful to the Constitution. When judges abandon originalism and substitute their own judgment for the text of the Constitution, the consequences can be disastrous. Such actions undermine the rule of law and erode public trust in the judiciary. They undermine the rule of law and erode the very foundations of our republic. It is essential for the judiciary to uphold the principles of justice, equality, and the original intent of the Constitution to ensure the continued strength and stability of our nation. Section 5. The Path Forward. Restoring Constitutional Integrity. In conclusion, when deciding if a law is unconstitutional, we must look to the Constitution itself. Thomas Jefferson wisely advised, "On every question of construction of the Constitution, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit of the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed." These words remind us of the timeless wisdom embedded in our founding document. The Constitution provides the government with a very limited list of powers and duties. If a power is not explicitly granted by the Constitution, the federal government has no authority to legislate on that issue. Every public official, whether elected or unelected, takes an oath to defend the Constitution against all enemies, both foreign and domestic. Yet we find ourselves in a time where many in government have become enemies of the Constitution they swore to protect. It is imperative that any public official who advocates for unconstitutional regulations be immediately removed from office and charged with sedition. The government's power is not meant to extend to every aspect of our lives. Rather, the Constitution is designed to limit governmental power and protect the rights of the people. As we move forward, we must remain vigilant. We must hold our leaders accountable and ensure that they respect the boundaries set by the Constitution. This is not just a task for our judiciary, but a duty for every citizen who cherishes liberty and justice. Together, we can restore constitutional integrity and safeguard the principles upon which our nation was founded. Stay frosty, my friends. Keep your head down and your powder dry.